Arthur, I appreciate your comments. The concept that you brought up is important, and it's something that should be factored in. Is there anybody else who wants to say anything for the good of the order? If not, our next meeting is October 22nd, and I want to thank everybody for coming today. These meetings brighten my day. Yes, Arthur.
I did want to say one thing on section 6. I brought a handout. We have an organization, Washlight. A number of our members of our organization from Snohomish County were concerned about a recent Court of Appeals decision, INRI AEH, involving where the Court of Appeals used some rather extraordinary language that I've virtually never seen before. We've never seen before in a Court of Appeals decision.
August 20th, 2019. Washington Sunshine Committee members and Chairman Schwab, thank you for your continuing work improving the Public Records Act. As a group of citizens committed to open government, we appreciate the committee's many accomplishments and the integrity, professionalism, and high standards of conduct demonstrated by all of the members of the committee. However, a recent published decision of Division 1 has raised concerns on our part as to the conduct of one of the members of your committee, and whether it is consistent with the broad remedial purposes of the PRA. Attached to this correspondence are excerpts from an August 12, 2019 published decision of Division 1 in cause number 76964-2 in RE, the matter of AETH. In this case, the Court of Appeals found not only that the Snohomish County VGAL program and Ms. DiVittorio engaged in abusive litigation tactics, but that Ms. DiVittorio created an appearance of fairness problem by threatening to take legal action against a litigant on behalf of the Superior Court for their filing of evidence in a case pending before the court. From the published opinion, it is apparent that Ms. DiVittorio orchestrated and participated in a 2-year-long pattern of suppression of evidence of misconduct of the VGAL staff members, as well as abusive litigation tactics that included document dumps that purposefully made relevant evidence hard to find, and destruction or withholding of relevant emails, the profiling of false and misleading statements, and perhaps most egregiously, the mysterious disappearance of the entire hard copy file during post-trial proceedings regarding the VGAL's misconduct. Ms. DiVittorio also brought 2 Snohomish County Superior Court judges, including the presiding judge, into a hearing on November 4, 2016, creating an appearance of improper influence or pressure on Judge Ferris, and the appearance of an attempt to intimidate or pressure the apparent's attorneys, giving the appearance of sending home a message that Superior Court judges were personally opposed to their motion and siding against them with the VGAL program attorney, who had clearly committed courtroom misconduct. The Court of Appeals, in this recent published opinion, found that the participation of Ms. DiVittorio created a serious appearance of fairness problem, and we, the board members of the Washington League for Increased Transparency and Ethics, Washlight, respectfully request that this committee carefully consider whether a similar appearance of fairness issue might be presented by her continued participation as a member of this committee. Sincerely, Washlight board members David Koning, Sherry Bockwinkel, Brian Green, Lori Shavlik, and Arthur West. In the Court of Appeals of the State of Washington in the matter of the dependency of AETH, minor child, State of Washington Department of Social and Health Services Respondent versus Nilisha Starvian Belafon Araydon and Carrie Allen Hayes, appellants. Division 1, published opinion, filed August 12, 2019. Page 15. Additionally, Judge Ferris found that after the termination trial and during the subsequent litigation on VGAL misconduct, DiVittorio met with Hagen and advised and directed Hagen to make motions to strike and redact the parents' pleadings in this case, and gave directions on what to include in the motions and advice on the meaning of applicable law. DiVittorio also sent the mother's attorneys a letter threatening to take legal action against them personally for filing certain evidence in this case, which essentially threatened to take some legal action against the mother's attorney if they did not capitulate and allow certain pleadings to be stricken or redacted as was being requested by Haugen. Judge Ferris also found that DiVittorio also created an appearance of fairness issue when DiVittorio repeatedly referred to the Superior Court and the VGAL program collectively as the court in response to Aradon's motion for sanctions. DiVittorio brought 2 other Superior Court judges, including the presiding judge, to the courtroom for the hearing to sit directly behind DiVittorio. In addition to creating an appearance of improper influence or pressure on Judge Ferris, this action also created an appearance of an attempt to try and intimidate or pressure the parents' attorneys. Finally, Judge Ferris found that the VGAL program used abusive litigation tactics against the parents. These included post-trial document dumps that purposely made information hard to find, the destruction or withholding of relevant emails, and the proffering of false and misleading statements. Perhaps most egregiously, VGAL Brooks' entire hard copy file for this dependency mysteriously disappeared from the VGAL's program's possession during the post-trial proceedings regarding the VGAL's misconduct.
Concerning the conduct of a member of this committee, I would ask that this committee look at the pattern of misconduct, the pattern of suppression of records, threats against attorneys to suppress information, the systemic 2-year-long history of hiding information, of misconduct of the GAL program in Snohomish County, the deliberate conduct to impair the fairness of the tribunal by bringing sitting judges in to attempt to influence the proceedings. All of this documented not by accusations by any of us, but by a published decision of Division 1 of the Court of Appeals involving Ms. DiVittorio, a member of the committee. None of us participated in this. We're not aware of the facts, but we think that these allegations or conclusions of the Court of Appeals and the 319-page long ruling of Judge Ferris of the Snohomish County Superior Court should be reviewed by the members of this committee in determining whether all the members of this committee are upholding the high standards of ethics, professionalism, and responsibility that the public has come to expect from its members of the Sunshine Committee. Thank you for your time.
I haven't had a chance to review your memo, but we will do so and make an appropriate response. Thank you.
Thank you very much.
Okay.